Hi, everyone. I hope you're doing really well today. Thank you for joining. We'll give it a moment as people join the room. While we wait, let's kick things off and with a quick weather update as we usually do. Drop a note in the chat with your location and how the weather is treating you today. And of course, let me know if you can hear me loud and clear. Oh. Oh, it's cold. Hi, Lisa. So on my side, I'm in Provence in the south of France, and it is really sunny, but really windy. So hopefully you have a better weather than mine. Hi, everyone. Sunny Cork. Very good. Freezing. Sunny Dublin. Excellent. So thank you for joining. It's great to see everyone coming in the room. A warm welcome to you all. And we're excited to dive into today's topic, which is employment law changes. I'm Marina, Marketing and Brand Manager at Great Place to Work, and I will be your host for today. And before we get started, I have a few updates for you. The first one is a quick reminder about some upcoming deadlines. For this aiming to be recognized as a best workplace in Ireland or best workplace for women in 2025, the certification deadline is November 29th. Survey slots are being filled up really fast this year again. So if you haven't signed up or renewed yet, now is the time. And if you have already renewed, you're automatically in the running as long as you reach certification. And if you want to know more about how to be recognized, you can book a call in the chat. I'm going to pop a link there for you. And if you're already certified, mark your calendars for October the 16th. It's Certification Nation Day. This is our global celebration of the year for our community of certified organization. And it's a fantastic opportunity to showcase your company culture. So don't miss this global social media campaign with us. And lastly, it is the 6th edition of our Employer Branding Summit that will be held at the Epic Museum once again. And the summit will feature insightful talks from experts about talent attraction and talent retention. And you can register through the link I'm going to pop in the chat again. There you go. Great. Now on today's webinar, we're thrilled to have Catherine Monahan. She's Senior HR Consultant at Action HR Services, and we will discuss the latest changes in employment law. As we go through the session, feel free to ask any question to Catherine using the Q&A function. We'll do our best to cover as many as we can today. We'll also be sharing the slides and the recording in a follow-up email, so don't worry about taking detailed notes. And let me introduce Catherine properly now. She's been a member of CIPD for over 20 years and is currently a chartered member. She's trained a mediator and trainer, and some of you in the call might already know Catherine as she's coaching hospitality businesses as part of the Full Ireland Employer Excellence Programme. Catherine, it's great to have you here today. How are you?
Oh, delighted to be here again, Marina. Thanks for inviting me.
Thank you for joining. Fantastic. So before we dive in, we'd love to know how familiar everyone is in the call with the recent employment law changes. And we're going to take a quick poll for that. So you're going to receive that on your screen. So the first one and the second one. How familiar are you with the recent changes in employment law? Very familiar, somewhat familiar, not familiar at all. And the second one is, how ready do you think your organization is for upcoming changes in employment law? Very ready, somewhat ready, not ready, or not sure. We'll give a few seconds for people to fill in the poll. That'll give us a good understanding of where we are at today. Great. I can see a lot of answers coming in. Cool. I'm going to share the results now. So most of you are somewhat familiar with these changes and somewhat ready. So this webinar is going to be really useful for us all today. So that's why we decided to do this webinar again this year based on your feedback on that regular check every year. So let's start with what have been the most significant changes in employment law over the past year that employers should be aware of, Catherine?
Well, Marina, there have been so many as there were the previous year, and I think the landscape shows no sign of slowing down. So I spoke to you in August, I think it was last year. So since then, we have had the introduction of domestic violence leave. That was in November of last year. And that entitles employees who are or were experienced domestic violence or to assist another person who is or was experienced domestic violence to 5 days paid leave by the employer. So that was from November last year. And then we moved into January, and January saw the introduction of new on the spot fines, unfortunately, for employers by the WRC. And I'm going to discuss that a little bit today so people understand what that means. And then we had the long awaited code of practice on the right to request flexible and remote working. And we've had the first decision recently by the WRC in that. So I'm going to talk to you a little bit about that today. And it is good news for employers, I might add. And then auto enrollment, which is on everybody's lips. And I know a lot of businesses should be really prepared for that now. Only 35% of people in the private sector actually have pension coverage.
Mm.
So the government, well, we're the last country in the EU to introduce auto enrollment. So they wanted to ensure that that pension coverage was increased. So I'm going to talk a little bit about that today in more detail. And then we had the extension of parents' leave in August from 7 to 9 weeks. And then collective redundancy legislation. We had the introduction of legislation which enhances protections for employees facing redundancy caused by their employer's insolvency. Then we had the Employment Permits Act, and that was enacted just actually on the 2nd of September. And the regulations were published 2 days ago. They're 65 pages long, so we all need to get up to speed with those. And then I suppose case law, which is very important for us to understand what or how to interpret legislation in practice. We had the Carson versus Revenue Commissioners case. Now, I'm not going to discuss that today from a time perspective, but that saw the Supreme Court set out a 5-step framework for to follow to determine an individual's employment status. And mandatory retirement is big on the agenda at the moment. The government has a strategy to prolong or to keep longer working lives. So we're going to see a lot around that. But there was a very interesting Supreme Court decision earlier this year on mandatory retirement ages. And I'm going to talk about what that means for employers. So most of what I've just outlined, I'm going to talk about today. But as you can see, there's a lot on the landscape, and a lot to get your head around from an employer perspective.
Yeah, and actually, there's a lot there. What are the resources and support system available for employers to navigate these changes?
So employers, well, first of all, I would be saying that maybe sign up for webinars like this one to keep you up to date. I know myself when I was in industry, it's really, really difficult to keep up to date with changes while you're trying to do your day-to-day job and think strategy also. So definitely sign up for these webinars. I also would follow experts on LinkedIn, experts people and experts company. I would also go on government websites, the CIPD website, WRC website. So you have all those resources available to you to keep up to date with changes. I also would ensure that I make sure that my contracts and my company documentation is up to date and communicate those changes to your employees. The changes are no good if you don't communicate them. And also carry out a HR audit once a year. So that's my advice to employers to try and keep up to date. But it is really difficult, especially if you're a HR practitioner now, you
Of
know.
course. Of course. Great. Thank you, Catherine. So let's dive into these changes, right? I'm going to stop sharing so you can share your slides there.
Fantastic. Just bear with me now. The technology is always great. You want to make sure it works when you want it to work. I'm just bear with me.
So we can see your screens there. You just want to go full screen, I guess.
Perfect. Can you see that, or can you only see part screen?
Yeah, we can only see part screen. We can see your note side as well.
Up share and try again. Bear with me now. All right.
Right.
There we go.
Yeah, perfect.
Can you see me now?
Yeah.
Sorry about that. Takes
No.
some time.
No problem.
So to get started, I know our time is tight, Marina, so I will try and proceed as quickly as I can. So having a look at just the agenda again, we're going to start with, I'm going to talk a little bit about the national minimum wage and the new living wage. I discussed that a little bit last year, but I'm going to talk about it again this year. The Sick Leave Act 2022 and some interesting case law around that. The Workplace Relations Act 2015, Fixed Payment Notice Regulations 2023. They came into effect in January. That's the new on-the-spot fines I talked about. The long-awaited code of practice for employers and employees on the right to request flexible and remote working. That was in March. That was published. And the Employment Collective Redundancies and Miscellaneous Provisions in Companies Amendment Act 2024. That came into effect on the 1st of July. Then we're going to move on to the Employment Permits Act. And like I said earlier, that was enacted on the 2nd of September just. The extension of parents' leave, which came into effect on the 1st of August. The very interesting Supreme Court decision, Seamus Mallon versus the Minister for Justice on mandatory retirement age. Staying on retirement ages, the Auto-Enrollment Retirement Savings Systems Act 2024, which employers should, if they haven't started preparing for, should certainly start preparing for now. The general scheme then for the future, the general scheme of the Employment Restriction of Certain Mandatory Retirement Ages Bill 2024, and the General Scheme Maternity Protection Amendment and Miscellaneous Provisions Bill 2024. So that's what's coming down the line, some of what's coming down the line. So to start, we talked last year about the national living wage replacing the national minimum wage from 2026, or that's the government's plan. And the living wage will be set at 60% of the median wage in any given year, and that's expected to equal £13.80 this year. Now, it has been reported in the media that the Low Pay Commission have recommended to increase the national minimum wage in 2025 by between 80 cents and 120 per hour. Now, if that comes into effect, it means our national minimum wage is going to be between £13.50 and £13.90 an hour. Now, interestingly, the government has never rejected a recommendation from the Low Pay Commission. And I know that this is going to put a very significant pressure on already struggling businesses from a financial perspective. But I do understand, I suppose, if you're going to, if they want to achieve the living wage by 2026, then adopting an incremental approach, I suppose, gives businesses time to adjust and prepare. So I'm sorry I don't have good news to start with for employers. And this next recommendation from the Low Pay Commission is certainly not going to be good news. So the Low Pay Commission have actually recommended that sub-minimum wage rates for those under 20 years of age be abolished. And they're saying that they should be abolished no sooner than the 1st of January 2025. Now, why are they recommending that? Well, they took into consideration evolving policy in the EU, which shows growing moves against sub-minimum wages, and also the EU directive on adequate minimum wages, and that must be transposed actually just on another note by the end of this year in Ireland. And that EU directive on adequate minimum wages states that if there's any variations or deductions from the national minimum wage, then they should respect the principles of proportionality and non-discrimination and should pursue a legitimate aim. And the Low Pay Commission couldn't find a specific legitimate aim based on age alone for sub-minimum wage rates, and they couldn't find sufficient evidence to justify retaining them. Now, just in terms of, to remind us all, employers, what sub-minimum wage rates are, employers can pay 70% of an employee's of the national minimum wage to those under 18 years of age. They can pay 80% of the national minimum wage to those that are 18 and 90% of the national minimum wage to those that are 19. So what the Low Pay Commission has actually recommended is that a study is conducted after 2 years if they are abolished, if the rates are abolished. A study is conducted after 2 years to determine if there was any adverse effect on those in particular under 18, and also to see how those employers who employ a high proportion of teenage workers can be supported. And we know that they're mostly concentrated in the accommodation, food and retail sectors. Those are the sectors that are really finding it tough. So this is going to be putting additional burden on them if it does come into effect. Now, we talked last year about the Sick Leave Act. A lot of the things I'm going to be talking about this year, we talked about last year, but we know that from the 1st of January 2024, employees are entitled to 5 days of employer paid sick leave in any one calendar year, and that's 70% of an employee's wages up to €110 a day. Now, it was proposed to increase the entitlement to 7 days in 2025 and 10 days by 2026. However, the Minister TD, Emer Higgins TD, said that any further expansion of the scheme is subject to an economic assessment because there's growing concerns in the business community about the increasing cost of labour regulation on doing business. So, you know, and we can see that from just what I've spoken about with regards to, you know, the abolishment of sub-minimum wage rates and the increase in the national minimum wage. Now, I just wanted to touch on case law with regards to the Sick Leave Act. Now, there's not a huge amount of case law in the area, but what there is includes testing of whether a company sick leave scheme is more favourable as a whole than the statutory sick leave. So we know under legislation that if companies have a sick leave policy and the terms are as or more favourable to employees, then they don't have to pay the additional statutory leave, but this must be outlined in a sick leave policy. Now, one very interesting case, well, I found it was interesting this year, was in May, and it was an anonymised case. And an employee was awarded €1,400 for breaches of, for the employer breach of the Sick Leave Act. Now, what happened was the employer was disciplining the employee for a high level of absenteeism. But because the employer took the time period that the employee was on statutory leave into account when they issued the written warning, the WRC found that they were in breach of the Act, because we know that when an employee is on statutory sick leave, they have to be treated as if they have not been absent. So I suppose the lesson for employers is to ensure that we aren't seen to penalise employees for availing of their statutory rights. So I just found that case very interesting, and I thought it was a good learning for us. So moving on to the Workplace Relations Act 2015, Fixed Payment Notice Regulations 2023. some of these titles are an absolute mouthful. Um, and so they were published, like I say, on the 12th of January, and they consolidate new and existing fixed payment notice, which means on-the-spot fines for employment law offences. Now, we know that a W&C inspector can enter any of our premises without warning to check to make sure that we're maintaining adequate records and complying with employment law. Now, what they can do is they can issue compliance notices or fixed payment notices, which is on-the-spot fines, or both. Now, they've introduced 3 new on-the-spot fines from January, which I'm going to talk about in a second. But I just want to say that fines are actually per breach of the relevant employment legislation. So it can be really significant financial cost for large employers or even small employers. So you can see now in the diagram, these are the 3 new on-the-spot fines. The first is €1,500. So that's for each breach. If an employer fails without reasonable cause to provide an employee with their terms of employment within 1 month of their commencement date, and we know this time frame was changed under the Transparent and Predictable Working Conditions regulations. And then we have tips and gratuities fines, so €750 when an employer doesn't provide employees with a written statement on the distribution of tips and gratuities or fails to treat a service charge as a tip, and €500 when the employer doesn't display a tips and gratuities notice or a contract workers tips and gratuities notice. So you can see how the fines are quite hefty. And when you combine them with the old fines, then, I suppose for employers, what's the lesson? To make sure that we keep our records up to date and that we're complying with employment law, in a nutshell, I suppose. I know it's easier said than done. So, the code of practice that's on everybody's lips at the moment on the right to request flexible and remote working. So first of all, the code sets out details of the processes that employers and employees must follow when they're making and managing requests for flexible working and remote working. Now, before I go into further detail, I just want to say that if you haven't updated your work-life balance policy, or if you don't have one, there's a fantastic template on the WRC website for developing a work-life balance policy. It'll just take you through it all. So that's where I would advise you to go to. They've also template applications for flexible working and remote working, so it'll just save you work. So before I go into details, I just wanted to say, and I mentioned it earlier, that it's widely reported in the media that since the code was published, there have been many cases. The last count, there was 18 complaints to the WRC in relation to remote working requests specifically. And that first decision was issued recently. And the case was Alina Karapko versus TikTok Technology. And the WRC found in favour of the employer, even though the employee had made a comprehensive case for remote working. So the good news for employers is that the WRC cannot assess the merits of any decision. They can only assess the process that led to the decision. Hence, it's really important that you get to grips with what that process looks like as an employer so you can ensure you follow it. So in this case, the adjudicator confirmed that the employer had followed the process. So what does that look like? Firstly, and it's under Section 21 of the Act. So firstly, to consider the employee's request, looking at the employee needs, the business needs, and the requirements of the Code of Practice. And within 4 weeks of receiving the request, either approve it, refuse it with reasons in writing, or in writing extend the duration to allow you to assess the request by a further 8 weeks. So that's the process according to Section 21 of the Act. So now just moving on, just to touch briefly on, because the code is quite detailed, but but the most important factors in it. So all employees can request remote working arrangements. However, for flexible working arrangements, employees with children under 12 or 16, if child has a disability or illness, and those with care and responsibilities to specified persons for serious medical reason may request flexible working arrangements. Now, employees can actually put in their request on the first day they join work, but they must have 6 months of continuous service before the arrangement can commence. And when they're assessing if the employee has 6 months of continuous service, any gap in employee service of less than 26 weeks will be discounted. So it's important to bear that in mind if there's a gap in service. So an employee must give you 8 weeks notice in writing if they want to make flexible working request and a remote working request. And for flexible working, they must include the form of flexible working being requested. So is it part-time, is it term time, is it compressed hours, what is it? The starting date and the proposed duration. For remote working, they should include how many days, which days are being requested, the start and end date if relevant, and the reasons for the request. And there's examples outlined in the code. They need to inform you where they're going to be working remotely. Will it be at home or at a hub? And information on the suitability of the location. Again, detailed information in the code with regards to the suitability of the location and what information the employee must provide. And you as an employer can request additional information if you need it to support the application. Now, like I said, no later than 4 weeks after receiving the request, approve it with written agreement. That needs to be signed by both parties. Refuse it in writing, outlining the reasons for refusal, or extend the duration by no longer than a further 8 weeks. So you get 12 weeks in total. You need to consider, when you're considering the request, you need to consider the business needs, the employee needs, i.e. why are they requesting it, and the requirements of the code. So for the flexible working, it's considered business and employee needs, and for remote, it's considering business, employee, and the requirements of the code, just to make that clear. And you need to consider the suitability of the role and suitability of the employee. Now, again, the code of practice outlines a list of questions. It's really helpful to help you consider the suitability of the role, and they have a list of questions to help you consider the suitability of the employee. So you can go through them when you're actually considering those 2 points. And all requests, it says in the code, must be reviewed in an objective, fair, and reasonable manner. Now, the WRC states that if an employee has concerns about their request not being considered appropriately, then they should bring it up informally at first with the employer, and following that, if there's no resolution, use the formal grievance procedure. Again, remember, good for employers, WRC has no legal power to assess the merits of any decision, only your process. So it's really important that you follow that process. And the WRC may direct the employer to comply with specific provisions of the Act and award compensation for flexible working, quite hefty, 20 weeks remuneration, and for remote working, 4 weeks remuneration. Watch the space. There's going to be a lot more developments for sure in this area, and I know a lot of employers are struggling with this at the moment. So moving on to, I said about the other mouthful, well, this certainly is a mouthful, the Employment Collective Redundancies and Miscellaneous Provisions and Companies Amendments Act 2024. And that commenced on the 1st of July, and it enhances protections for employees facing redundancy caused by their employer's insolvency. So I suppose just to remind yourselves on what collective redundancies are. So collective redundancies are where the number of employees an employer proposes to dismiss in any 30-day period exceeds the relevant threshold, and that threshold varies with the size of the employer's business. Now, Sections 9 and 10 of the Protection of Employment Acts 1977 to 2007 obliges employers to undertake a 30-day consultation and information period with employee representatives and notify the Minister for Enterprise, Trade and Employment of collective redundancy proposals at least 30 days before they take effect. And those obligations have now been extended to responsible persons. So who are responsible persons? Well, there's the list there: liquidators, provisional liquidators, receivers, or any other person appointed by the court where that person has assumed full responsibility for the management of the business concerned. Now, employees can seek redress from the WRC when employers have affected collective redundancies prior to that 30-day notification period, and they can be awarded up to 4 weeks remuneration. Very hefty penalties for employers as well. They can be up to 250,000 fine and criminal convictions. So really important that if we are having to unfortunately implement collective redundancies, that we follow this legislation. The Employment Permits Act, moving on, 2nd of September, that came into effect. And I talked about this last year, actually, spent a good bit of time on it. It was a bill at that stage. And the Act aims to consolidate the law concerning employment permits and modernise the employment permit system. Now, I just mentioned earlier as well, the regulations were issued 2 days ago. There's 65 pages, so we all need to get up to speed with these. But just to explain why there's regulations. So the operational detail has now been moved to regulations, and the reason for that is to facilitate a more agile employment permit system, to allow the minister to make changes without having to change primary legislation, because that takes such a long time. Now, what's new? Well, we have the introduction of seasonal employment permits. So where a employer wants to employ foreign nationals for seasonal temporary roles, they're going to have to become an approved seasonal employer, and they're going to have to apply annually to be approved. Now, permit holders can work for 7 months of the calendar year. What's new is the employer is going to have to provide accommodation and appropriate health insurance for the permit holder. And there's going to be a pilot scheme which is going to be run in 2025 in the horticultural sector only. Now, just a tip for you all, there's a very helpful information note on the Department of Enterprise, Trade and Employment website of these changes. And also it says that they said that they're going to keep us updated on the revised legislation. So have a look at that if this is an area, of particular interest to you as an employer. So the next major change is that holders of a general employment permit or critical skills employment permit can apply to change employer after 9 months. They won't need to apply for a new permit. They can stay on their current permit with the new employer, but they have to carry out the same role with the new employer if they're on a general employment permit, or the same category of role if they're on a critical skills permit for the new employer. The contract for services permit has been expanded now to include subcontractors, and agencies can now be the employer of a permit holder. Unfortunately, we still have the labour market needs test. So employers that are applying for seasonal employment permit, general employment permit, and contract for services permit will still have to complete that. However, they won't have to advertise in the national newspaper. They still will have to advertise the positions on Eurace, Jobs Ireland, and one other online platform, and they will have to advertise the position for a minimum of 28 days. That's what was previously, and that's what it is now going forward. So that's very, very brief synopsis of the Employment Permits Act for you, and the major changes as I see them. So parents' leave, like I say, was extended from 7 to 9 weeks from the 1st of August. Good news for those employees that have children under the age of 2. So it entitles each parent now to 9 weeks parents' leave during the first 2 years of a child's life, or in the case of adoption, within 2 years of the placement of the child with the family. And for those employees that have already taken the 7 weeks leave, they could take the additional 2 weeks if their child is under 2 on the 1st of August, or their adopted child is with the family less than 2 years on the 1st of August. For employers, you don't have to pay an employee while on parents' leave, and the employee may, if they have enough PRSI contributions, qualify for parents' benefit from the state. And this retirement is the word on everybody's lips at the moment. So I found this case very interesting and actually good for employers. It clears up a question that we had from an employment law perspective. So just maybe to say that retirement is a deeply evolving area of law. There has been an increase in 173% in 2003 of age discrimination complaints. And there's been many challenges on mandatory retirement ages. It's a very emotive issue. I think it's because we're all affected by it at some stage in our working lives. And it will definitely continue to evolve given the government strategy to encourage longer working lives. And we're going to see that in this bill, the restriction of certain mandatory retirement ages bill that I'm going to be talking about shortly also. So just to remind ourselves, there is no statutory mandatory retirement age in the private sector, but there is in the public sector. However, legally, under the Employment Equality Act, a company can set a mandatory retirement age, provided they can objectively and reasonably justify the age they have chosen by a legitimate aim, and the means of achieving that aim are appropriate and necessary. So, putting that aside, now let's have a look at Seamus Mallon. Who was he? Well, Seamus Mallon was a practicing solicitor and he was a revenue sheriff. And he challenged the mandatory retirement age of 70 for sheriffs. He argued that maintaining the age of 70 was discriminatory based on age without sufficient objective justification. And he requested the Minister for Justice to amend that age to 72, but that was declined. And the case went the whole way to the Supreme Court. And the Supreme Court upheld the High Court finding in favour of the state to uphold the mandatory retirement age of 70 for sheriffs. And the Supreme Court held that the legitimate aims that were identified, or the aims that were identified for having that mandatory retirement age, were legitimate. So some of the aims that were put forward by the state were for intergenerational fairness, to create a balance of ages in the workforce, for personal and professional dignity. They had a few more, but they were some of them. So there was 4 core issues of appeal. It was a pretty complex case. I'm not going to go through the whole complexity with it, but I'm just going to go through what I think is relevant. So one of the core issues of appeal were, can mandatory limits be set in relation to defined groups based on general probabilities of age, health, and competence, as opposed to individual characteristics on an individual assessment? Now, Seamus Mallon argued that a blanket mandatory retirement age will not be justifiable where individual assessment is possible, and that came from the Donnellan decision previously. Now, interestingly, throughout 2023, the WRC in their decisions emphasised the need for reasonable and objective justifications of mandatory retirement ages to achieve a legitimate aim. But they said that those aims should be individually assessed on a case-by-case basis. However, For us, this is good. The Supreme Court clarified that a general mandatory retirement age does not require individual assessments, as this would undermine the policy's consistent and systematic application. And they held that avoiding the need to individually assess each person's ability to work as they get older is a valid reason for having a general mandatory retirement age, because having to assess every person individually could lead to disagreements and could affect an employee's dignity. So, in a nutshell, what are those points to note for us? Well, first of all, it clarifies that individual assessments are not required for a general mandatory retirement age to be lawful, that an employer is not required to justify the application of a general retirement age to an individual employee, and that a general mandatory retirement age is lawful provided it can be objectively justified by a legitimate aim, and that it's applied consistently, systematically, and coherently. Now, what I would say to employers is you need to make sure that those legitimate aims that you're identifying are relevant to your workforce and they're not merely generalised. And employers can still allow longer working on under the WC Code of Practice on longer working. If I was going to give one piece of advice here, and I've seen it from case law in the WRC, you need to be really familiar in what it entails in that WRC Code of Practice on longer working as an employer, and you need to make sure you follow it. It's really, really helpful in setting out guidelines on the retirement process itself and on what to do as an employer, the steps to take should your employee request to work past the mandatory retirement age. So if we don't follow codes of practice, we know that it can undermine the employer's defence. And we've seen that time and time again, especially under age discrimination claims and retirement in the WRC. And we're staying on retirement, but we're talking about the Automatic Enrolment Retirement System Savings Act 2024. And I am just, so hold on till I just go back. So it was signed into law on the 9th of July, and enrolments now, the government are saying that enrolments are expected to be in place by the first quarter of 2025. That remains to be seen. But I suppose if I was an employer, I would be preparing as if enrolments were going to be in place by the first quarter of 2025. So it will see everyone earning over 20,000 a year from all employments, aged between 23 and 60, automatically enrolled in a new retirement savings system where there isn't already a contribution through payroll to a company or private pension. Now, who is going to be excluded? Self-employed, those not earning 20,000 a year from all employments, and those that are already in a PRSA or occupational pension scheme. It's estimated that 800,000 workers are going to be enrolled, and that's a massive amount of people that don't have, well, through payroll, don't have arrangements made for retirement from a pension perspective. So it's going to be gradually phased in. The employer and employee contributions are going to start at 1.5% of gross salary, so important to communicate this to employees. It's going to auto-escalate every 3 years. So it's going to be 1.5% for employees and employers in year 1, 3% in year 4, 4.5% in year 7, and 6% in year 10. The state is going to make a contribution in place of tax relief because that's what they do now. And it's actually going to equate to 25% tax relief. All contributions are going to be calculated on the employee's gross salary, and it's going to be up to a maximum gross salary of 80,000. There's going to be no waiting period, and it's not going to be possible for employees to make extra contributions in the first few years. I know a lot of people have been asking that question. So let me touch on the key features. It's going to be the pot follows members approach. What does that mean? It means that as I moved from job to job throughout my career, I'm going to keep the same pot. I have to stay in for 6 months, and we can opt out in months 7 and 8. And in months 7 and 8, following a contribution rate change, we'll be able to get a refund of our contributions if we do that then, but the other contributions will stay in the pot. At any other time, we can suspend our contributions, but you won't get any refund. All the contributions will stay in the pot. After 2 years, you'll be opted back in again, provided the eligibility criteria is met. And this new central processing body, the National Automatic Enrolment Retirement Savings Authority, is going to be set up to administer the system. And the bulk of administration is supposed to fall on them, but we'll see what happens when it starts. So how are eligible employees identified? Well, it's going to be based on payroll data submitted to revenue. So, to identify if they're earning the 20,000 over all their employments. Contributions will be calculated automatically by payroll software. If an employer doesn't have payroll software, there'll be an employer online hub where they can make contributions and check their records. There's going to be fines and penalties for employers as usual if we don't comply with legislation. And there's going to be no standards for existing pension schemes to meet when automatic enrolment is first introduced. So what do I mean by that? I mean that if there's a contribution through the payroll now to a pension scheme, then that person won't be automatically enrolled in the retirement savings system. If there's a pension scheme already in place in employment in the employer with the employer, but not all employees are enrolled, which is quite likely, and those employees meet the eligibility criteria, they will be enrolled in the system. What does that mean for employers? It means there'll be two systems run side by side. So what I would suggest to you is, if you do have a pension scheme in place and not all your employees are in, and you don't want to have a second scheme running at the same time, you could try now communicating to your employees to encourage them to go into the scheme, your own pension scheme. And maybe if you had a waiting period, because a lot of pension schemes have a waiting period, for example, 6 months, you could maybe think about not having that, getting rid of that, because employees will be automatically enrolled from day dot. I hope that makes sense. And standards will be developed in conjunction with the pensions authority when contributions rates increase, to make sure that nobody is worse off in any other pension scheme than they would be in automatic enrolment. We're nearly there now. We're coming to what's happening for the future and things that we should be mindful of, what's coming down the road. So again, retirement, the General Scheme of the Employment Restriction of Certain Mandatory Retirement Ages Bill 2024. So firstly, might I say that this bill, if enacted, will have no relevance to those employers that don't have a mandatory retirement age, or those employers whereby their mandatory retirement age is at or above the state pension. That will not be relevant to those employers. This bill was published as a response to the Pensions Commission recommendations and implementations plan. And the purpose of it is to ensure that employees are not, or people or workers are not left without an income from when they leave employment till they can access the state pension. So in a nutshell, what does it mean? It means that if the mandatory retirement age is less than the state pension age, the employee will now be able to choose, if this is enacted, to either retire at the state pension age or at any time between your mandatory retirement age and the state pension age. So effectively, they can opt out of your mandatory retirement age. They have to give you 3 months notice in writing, and they can withdraw their notification, but they must provide you with their contractual notice. Now, just importantly, this will not affect any retirement age set out by law. And finally, we're just going to touch on the General Scheme Maternity Protection Amendment Miscellaneous Provisions Bill 2024. That was published on the 24th of July, and it will allow employees to postpone all or part of the maternity leave for up to 52 weeks if they're undergoing treatment for cancer or for a serious physical illness, provided that that time is medically certified. And there are reviewing at the moment to see if they're going to extend that provision to people with very serious mental health issues. Now, if the bill is enacted, it's also going to amend the Employment Equality Acts, and it's going to restrict employers from entering non-disclosure agreements with employees who allege discrimination, harassment, sexual harassment, protected disclosures, or victimization. And unless that's at the employee's request. So if it's at the employee's request, the employer must provide the employee with independent legal advice at the expense of the employer for the agreement to be enforceable. That has been a whistle-stop tour, I know, of changes to employment law and upcoming employment law. But thanks a million for taking the time to listen to me today.
Thank you so much, Catherine. That was a lot. I received many questions in the Q&A and chat. We'll try to cover as many as we can, as we said. And if your question is not answered live, Catherine will follow up with you kindly after the webinar to answer your question. So, Catherine, the first question we received was about remote working. Does the employer have to pay for employees' equipment to work from home once they approve a remote working request? And can the employee work from anywhere, example, another country?
That's an interesting question. I'll start with can they work from another country? So listen, there's tax implications. I wouldn't be 100% au fait, but I know there's tax implications from working for allowing employees to work in another country. You'd need to consider that. You'd need to consider insurance. You'd need to consider jurisdiction, time zones, and I suppose the day-to-day management of the employment relationship implications. But definitely there's tax implications. So I would be saying, while they can, there's things that you need to consider. So in the code of practice, it talks about the employee home location, as in Ireland. So probably best for to be in this jurisdiction. With regards to paying for employee equipment to work from home, there's no legislation governing costs associated with remote working. And the WRC have indicated that costs are generally agreed between the parties and provided for as part of their terms and conditions. Now, I know that the Revenue has produced guidelines for employers on provision of equipment and facilities and home expenses. Just for employees, and you probably know this yourself, but if you are working from home, you can get a tax deduction of up to 30% of the cost of heat, electricity, and broadband. And also, employers actually can provide an allowance for employees to work from home of €3.20 a day. So I hope that answers the question.
Do you want to have a look at the Q&A box there, or the chat? And
yeah, I think there was questions before we came in.
yeah, there is a question about can an employee keep contributing to their personal pension and be eligible for auto-enrollment?
So if your personal pension is not coming through payroll, they'll be eligible for auto-enrollment. But if it is coming through payroll, they won't be eligible for auto-enrollment. Any pension coming through payroll won't be eligible for auto-enrollment.
And how will the employee salary be assessed for eligibility for auto-enrollment?
So there's going to be a pay reference period to see if an employee meets the earnings threshold. And I suppose for a lot of employees, it's going to be evident from day one. For employees maybe that are working across different employments, or maybe on casual working, then there's going to be a 13-week reference period. Just nearly forgot that there. Yeah, 13-week reference period. Fantastic.
Nice.
I'm just looking, sorry, I'm just looking at some of the questions here.
In the meantime, Catherine, I know you shared a lot of cases when you were explaining the different changes. Where can we find these cases? Can you share some links of all the examples you
Yeah,
shared?
so I'll send them on to you afterwards. But WRC for sure, WRC website, that's where I get everything. And I go on to there's a decisions part in there. And it's really, really helpful. Like I said earlier, if you hook up to government websites, if you hook up to, newspaper articles, they'll give you, send you on cases, and then you can go and research where they came from. Um, also when we talked previously, Marina, and you were saying how people keep up to date, I think also it would be important, if you can at all, to maybe get a private consultancy or somebody that you can bounce things off. That's really helpful, because it's very difficult to even know what the legislation means in practice, you know. I see one here. Is it okay if I just go down? Yeah. So does the employee have to choose how their money will be invested? You don't actually. There is a default investment strategy. However, you will be able to choose how your money's invested. You can choose from a low risk, medium risk, or high risk investment strategy. The default one, depends as people go through their employment and coming near retirement. It'll be the low risk, that'll be the default, but it'll start, at a higher, um, probably higher risk. What sort of things can an employer look at when considering suitability of the role and suitability of the employee for remote working? Yeah. So, like I said, again, get onto that code of practice. It's an easy read, to be honest, and it gives you a comprehensive list of what things you need to be looking for. So just to touch briefly, so suitability of the role, it says to look, first of all, what type of work does the role entail? Can any of the duties be undertaken remotely? So you need to look and see if any of the duties can be undertaken. Does the role require a high degree of manual labour? Does the role include tasks that must be performed on site? Uh, Maybe the role requires access to equipment or data or technologies that can only be available on site. Does it require face-to-face engagement with clients or customers? Are others on approved leave? Is there any health and safety issues that need to be undertaken, or that need to be with working remotely? Sorry. And then with regards to the suitability of the employee, very helpfully, it talks about, first of all, does the employee have IT skills to work remotely? Have they met the performance standards for the role? Do they require minimal supervision? Have they shown that they can meet deadlines? Are they on an extended probationary period, a PIP? Have they a live disciplinary record on their file? Is their attendance suitable? I could go on. There's such a long list, but it's going to be brilliant for employers, because what they just have to do then is to go through, those questions, answer them. Again, the WRC can't assess the merits of any decision, only your process, so you can show that you've gone through a comprehensive process.
Thank you so much, Catherine. Maybe one last question before we wrap up.
Yeah, this is an interesting one. If this is okay, I'll answer this. Can a person enroll in auto enrollment if they do not meet the eligibility criteria? And very importantly to know that yes, they can, provided they are under the state pension age and they are working, and there's no contribution through the pension through payroll already to a pension scheme. They can opt in. And how they opt in is, when it's all set up, they'll be able to contact the authority and advise that they want to opt in. But that means that the employer is going to have to pay, and they need to assess, the cost, etc., of that. But yes, you can if you don't meet the eligibility criteria.
Great. Thank you, Catherine. So it's time now, and there are some questions we couldn't answer live, but as you kindly offered, you're going to follow up with these people to answer their questions. So
Sure,
if you have
no
questions
problem.
in the Q&A and in the chat, Catherine will follow up with you on your specific question. Thank you so much, Catherine, for today. That was super helpful for everyone, including me. Actually, I learned a lot. So thank you for coming again this year. We learned
My
a lot
pleasure.
today. And I hope everyone enjoyed it and have a good rest of the day.
Thanks a million, everybody. Bye bye.
Bye.
Thanks, Marina.